item number 3, can it be taken up after some time, madam?
Okay, you don't know finish with me.
Obliged.
Okay. Prayer for listening, if any, give it to the court master.
May it please, your Lordship.
Yes.
Lordship, I beg to mention for upgradation, my Lord, supplementary item 51. Lordship remembers on the Friday, Lordship had, being led by Mr. M.K. Chaudhary, my Lord. Lordship had,
Oh, yes.
yes, my Lord, this matter, my Lord, may be upgraded, my Lord,
Yes, we'll take it up. After the motions, we'll take it up.
after the motion. Can it be at 2, my Lord, if possible, my Lord?
At 2. Okay. No
At 2 p.m., my
difficulty. Inform the other side.
I'll inform the other side, my Lord, at 2 p.m.
Okay.
Deeply obliged. Deeply obliged.
Yes.
I also pray for upgradation of item number 34. Lordship has keep it consideration of for bails, Lordship, and the person concerned is in detention camp, Lordship. LCR has already received.
34, we are making a note, we'll take it up. Because we are making a note, we'll upgrade it.
Yes,
But we can't give the time right now.
Lordship.
Yes.
I want to adjourn item number 11, your Lordship. Vacation, your Lordship.
11, you want an adjournment? Okay, both sides are represented. The prayer made by counsel for the plenary counsel for the petition. List after ensuing winter vacation. 11.
Another PRA, your Lordship, item number 27. And it take about 2 years. There is no bail, your Lordship. 27, your Lordship. That high proportion is listed, but not
We are not giving a time, but we'll take it up.
Lordship. 27, your Lordship.
We'll try to take it up, 27. Okay.
Obliged, sir.
May I please, your Lordship? My Lord, I have prayer in item 33, my Lord. On last 2 occasions, my Lord, the LCR pertaining to his younger brother, my Lord, was called for, my Lord. I have got the instruction, my Lord. The records have been sent so far as the younger brother of the petitioner is concerned, my Lord. I am praying before your Lordship, my Lord. Registry may kindly be directed to take the, my Lord, the case records of the younger brother of the petitioner.
It has reached the court.
It has reached the court,
You give us requisition slip.
my Lord.
We'll try to get it.
Leave.
Give it to the court master.
My Lord.
May I please, Lordship? Lordship, I beg to mention item number 32, Lordship. Kindly pass over for the day, Lordship, and fix the vacation.
32. Same order. Item 32.
32.
Adjournment.
Deeply obliged. May I please, your Lordship? Lordship, I beg to mention item 15 and 22. My senior is annual, Lordship,
15
and 22.
26.
Sorry, Lordship, 15 and 22.
20.
22 and 15.
22.
Matter may adjourn after vacation. Obliged.
15 and 22. Okay, same order. Okay.
May I please, I beg to mention item 13, my Lord.
1330.
It may kindly be taken after vacation, my Lord.
30. Okay, same order. 30.
May I please, your Lordship? Lordship, I beg to mention item number 23. Matter may be taken up after vacation, your Lordship. We have got a petition.
Same order. 23.
Obliged.
I believe you, Lordship. My Lord, I am praying for listing IM.
Listing due to the court master.
That's them.
The modification of this.
Orders item number 43.
I am for the respondent, my Lord, KV the respondent.
What is this IE for?
A respondent.
No.
I was for, it was filed by FCI,
For?
Food Corporation, for condonation of delay.
Okay, then we'll take it up after some time.
Lordship,
Then we'll take it up after some time.
nobody appears, my Lord. Lordship may do one thing, only 6 days of delay. That may be condoned. And this is a matter which can be disposed of, my Lord, at the stage of admission hearing. That way, Lordship may post it. I don't have any objection to 6 days of delay, my Lord.
Okay.
And put it sometime after Bihu, my Lord.
Okay. Okay. Heard Mr. BK Singh, the counsel for the applicant. Also heard Mr. AC Barbara, learned senior counsel, assisted by
And
Miss MD, learned counsel for the respondent. Next one.
Lordship may not quote me, Lordship may condone
No, no, it's okay. I
it.
understand. And well, by filing this interrogatory application under section 5 of the Limitation
Right,
Act,
detail one.
the applicant is seeking condonation of delay of 6 days in filing the connected writ appeal. The learned senior counsel for the respondent has objected to the prayer made on the ground that the explanation for delay is vague. And therefore, application should not be allowed. Next one. Considering the projection that there was some delay in obtaining the approval from the competent authority, taking into consideration that the delay is only for 6 days, this interrogatory application stands allowed. So the delay of 6 days beyond the period of limitation in filing the connected appeal stands condoned.
I say,
Next one.
condonation to delay.
Uh,
Well, my learned friend appears
Ah.
for FCA.
I have recorded the name of Mr. BK Singh. He's here in Guwahati? No.
No, my lord.
Lordship,
Okay, your
Yes.
name then?
BKC, mine, Deepego,
Deepego on behalf of Mr. BK Singh.
BKC.
We are allowing this application unless you have objection.
Yeah.
It is higher application.
We are allowing your application unless you have objection.
No, I don't have any objection.
Okay. Mr. Barbara, we must hear her. That is a requirement.
Lordship
Uh,
may not say I am conceding, but from the court, my lord, it is
No,
condoned.
it's
And my
okay.
lord, the main case, my lord, Lordship may indicate that the matter, this is the type of matter which can be disposed of, my lord, at the admission stage. Last week of January.
Okay. The registry shall register the connected appeal and list the same in the admission column on 27/1/2024,
Lordship.
25.
Uh-huh. Well, no, let it be, my lord, on 29th, my lord,
Huh?
or 29th or 30th.
29th, okay, 29.
Lordship.
Forty-four.
May I please, your lordship? I am sorry to submit, your lordship. I have misplaced the file, so may I submit from the soft copy from mobile mails?
Yes.
My lord, earlier the petitioner appeared before this honorable court challenging the opinion of the tribunal, and accordingly this honorable court was pleased to pass the order dated 3/10/2024. Kindly turn to page 13, my lord.
Yes.
So the petitioner was allowed to go on bail, but at the relevant point of time, the case record was before the Borpeta SP, my lord. Subsequently, the matter was transferred to Baksha, my lord. So now the earlier order passed by this honorable court, there is a direction that if the petitioner wants to leave the jurisdiction, he should have take permission from the SP Borpeta. Accordingly, I filed an application before this honorable court, and Borpeta SP and Deputy Commissioner of Baksha and SP Baksha was implicated as party respondent. And now my prayer is that I may be allowed to take permission from the SP Baksha, my lord. He is not allowing with a specific direction from this honorable court. So my humble prayer is that the earlier order passed by this honorable court may kindly be complied by the Baksha SP, my lord. This is my humble prayer.
Okay. Now the records is with the Baksa.
Yes, my lord.
Okay. So Shamil, we are allowing this somebody is there. Heard Mr. S. Alim, learned counsel for the applicant. Also heard Mr. G. Sharma, learned standing counsel for the FT matters representing respondent numbers 2, 3, 6, and 7, and Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 4 and 8, as well as Ms. P. Barwa, learned standing counsel for the respondent number 5. This is for one. Union of India? No one. Union of India. Okay, none appears on call for respondent number 1. Next paragraph. By an order dated 25/10/2021, passed by this court in WPC 5573 of 2021, is page 10. This court had granted bail to the applicant with condition that he shall not leave the jurisdiction of Borpeta district without giving details of the place of destination and his place of stay to the Superintendent of Police within bracket border, bracket was Borpeta. It is next one. It is submitted that owing to the change in jurisdiction, the records in respect of the petitioner is now transferred to the office of this Superintendent of Police within bracket border, bracket close Baksa. Next one. Accordingly, it is submitted that by on the application filed by the applicant, this court by order dated 3/10/2024, passed in IA Civil 3063 of 2024, page 13, had allowed the impleading of Deputy Commissioner, Baksa, as well as the Superintendent of Police within bracket border, bracket close Baksa, as respondent numbers 8 and 7 respectively. Next, it is submitted that as in view of the directions contained in the order dated 25/10/2021, passed by this court in WPC 5573 of 2021, the Superintendent of Police within bracket Baksa, border bracket was Baksa, is not entertaining application filed by the application of the petitioner, sorry, applicant, for leaving his jurisdiction. Accordingly, this interlocutory application has been filed. Next paragraph. On consideration of the submissions made by the land counsel for the applicant, as well as the learned standing counsel for the FT matters, this interlocutory prayer made in this interlocutory application stands allowed. Next paragraph, it is provided that in the event the applicant, namely Chanmia, alias Chanmia, page number 1, spelling, applies before the Superintendent of Police within bracket border, bracket close Baksa, within bracket respondent number 7, the said authority shall do the needful in terms of the order dated 25/10/2021, passed by this court in WPC 5573 of 2021. Stop. The second last paragraph of the said order will stand modified accordingly. Next paragraph, this order shall be led together with order dated 25/10/2021, passed by this court in WPC 5573 of 2021. Okay.
My lord, I am ready to furnish fresh bail or if required. Yeah.
We'll do the needful in terms of, we have said that, we'll do the needful in terms of order dismissal. First off, the learned counsel for the applicant has submitted that the applicant is ready and willing to submit fresh bail bond if required by the respondent number 7. First of all, the set prayer is around. Okay.
I'm obliged.
45.
Mr. Dasgupta is not here.
Yes.
After some time, when Mr. Dasgupta comes, he will answer. Yeah, Mr. Sharma,
Lordship.
as per the prayer made in this interlocutory application, they are informing the death.
Yes, Lordship.
But then there's an opinion against the applicant
Yes, Lordship.
that will disturb their family.
Yes, Lordship.
So I think if you see Mr. Dasgupta, please tell him.
Yes.
Huh?
Either they have to impede or matter has to be closed, Lordship.
Oh, Mr. Dasgupta has come. Mr. Dasgupta, don't rush. Don't rush. Mr. Dasgupta, we are just looking at your prayer. Yeah, the applicant, the petitioner has died. You are wanting to bring him on record. But as per the decision of this court, in various cases, even if the person is declared to be a foreigner and he dies, then if you don't substitute their legal representatives, then what happens is that this opinion will haunt you, the legal heirs. Please take a call. We'll take it up after some time. Please take a decision, because if you inform the court about only the death, then we are likely to close it.
No,
Therefore, the opinion becomes final.
what happened in this case, Milord,
Hmm.
in another case, he was declared an Indian citizen.
No, we understand, but then again, you see the principles of res judicata applies.
Hmm.
The first opinion will prevail.
Yes.
So somebody in the somebody from your family will have to pursue that. Otherwise, this opinion, other family members will be haunted by it.
So
Because
far his wife
because
is concerned, it will not affect him, affect her,
Huh.
wife.
Our
But
children,
so far his children are concerned. One girl is there. His age is 20 or 21 years.
whatever be, but as per our decision, there are several decisions where we have held that once a person dies, after being declared to be a foreigner, his sons and daughters and other family members shall be proceeded with. So therefore, it will create some difficulty with your daughter. Please take a call. We'll take it up after some time. We are not hurrying with the matter. Please take a decision.
But sons and daughters are concerned.
There will be a
so far
separate reference. There will be a separate
sons and
reference.
daughters are concerned who born in India before 2004, they will be citizen of India.
No. Once their parents are declared to be a
No.
foreigner,
Once their parents are declared to be foreigners, if your worship goes through the section 4 is concerned, my lord, of the Indian
we
citizenship.
have seen that. That's why we are asking you. Please take a call. We'll do whatever you want, but please take a call. We'll take it up after some time if
Or
required.
I can. No, actually, I discussed this matter with them, my lord.
Hmm.
Then they told me that so far his wife is concerned. His name figured in NRC.
No, wife is not affected because wife gets
And
her
so
legacy
far
from
other
her.
daughters are concerned, who are elderly ladies, my lord, their name also figured in the NRC. But one daughter who passed BA.
No, you take a call. It will create some difficulty. That is what our experience says.
Let this matter be listed after some time. In the meantime,
At 2 o'clock, we'll take it up. or any other day you want.
Because then I have to substitute.
Yes.
Yes.
If your lordship desires, then
No,
because.
I don't desire
those are-
anything.
No,
Ah.
actually, I thought of this matter. But she told me that my name has figured in the NRC. Why I should invite a trouble? Because it is a third time
No,
case.
I think Mr. Dasgupta, after some time, he'll be able to help you to give you a decision, our decision of this court, where it has been said that the sons and daughters of a proceedee will have to be proceeded when the parents are declared to be a foreigner. He'll give you a decision after some time. Give him some time to
that
get
I
it.
have understood.
Huh.
Because of the section 4.
Because because we'll be now
Section 4 is concerned, if the parents are illegal migrant,
yes,
then her daughter,
yes, they don't get the protection.
that is, there is a cut-off date.
We don't
2004.
know. We don't know about that.
If the citizenship act is there. Anyway, we shall check it up. No problem. Your lordship.
Day after tomorrow?
Yes. Or today itself, it can be, let me bring that provision. But I am worried about one girl, one daughter.
No, that's why. Please take a please
This
take
is a very
informed
unfortunate
decision.
case. No, what happened in this case is third time he has been proceeded. Initially, he was proceeded, and then the court declared, yes, he is a migrant within the stream of 67 to 71. All right, he got his name enrolled, registered. Thereafter, again, another proceeding was initiated,
But then
wherein he declared as an Indian citizen.
no, then-
Third time is a very, very unfortunate case.
then you'll have to, I think it would be, you take a decision whether you want to proceed or not. Because we can't take a decision for you, but
No,
you'll have to
but
take a call.
your lordship has already disclosed your lordship's mind, then I have to substitute him. What?
I think so. That would be more appropriate. That is what at least we think. You take a decision because
No, decision is not mine. Decision will be their decision. I told her in that way. Then she told me why I should get myself into this. My husband proceeded thrice. And God knows again whether I may be again proceeded or not.
no, that we don't know.
There should have a limit of harassment, no?
But he can give you a decision.
No, all that decision not required because section 4 is very much clear.
That's why.
No decision is required in view of that.
So at 2 o'clock we take it up then.
Then I have to discuss with them. The lordship may post it after vacation.
After vacation, okay.
Right. I see he has been prosecuted. No, there should have a limit, I should say.
We can't pass a comment unless we hear the matter.
It has become a tool of harassment.
Heard Mr.
But
A.
he
Dasgupta, Lalit Senior
has
Counsel,
to do something for that.
assisted by Ms. D. Ghosh, counsel to the petitioner. All the respondents are represented. Next, on the prayer made by Learned Senior Counsel for the petitioner.
Let
Please
it-
start by answering winter vacation. You
let
make a
it be
mention, we'll
lifted
take it
after vacation in the month of January.
Yes. You make a mention, we'll call it. When you make a mention, remind us, we'll call it.
Your lordship fixing a date.
No, I'm not fixing a date.
Take it. Much of it. Then I have to go her daughter to be impleted. I want to bring his
No, merely
wife.
by impleading, we don't have a decision that merely by impleading she becomes a foreigner. There will be a separate reference, but she can defend that.
She is afraid of that. God knows what would happen. She told me specifically. My husband was proceeded thrice.
No, that's
And
okay.
God knows whether I will be proceeded among him. or not.
That is a call they will have to take. We can't say anything.
Anyway,
Supply item 52.
Lordship here, Lordship was pleased to grant an interim order, Lordship. And after, with the interim order, the petitioner, he went to appear with. Lordship, after the interim order, Lordship, he went to appear before the SP and there he came to learn that the place where he is residing now, Lordship, it falls under Kharpetia PS, not Shyampur, Lordship. Actually, he originally hails from Dholpur, Lordship, and it was under Sipazar PS. But subsequently, there was an eviction drive, Lordship. and they were displaced from there. Then they are newly settled in one area, Lordship, that is called number 3 Arimari. So since that police station was nearby, so he thought that Syampur will be the police station, but it is Kharpetia, Lordship. So my
You
prayer
want
is
the
that
amendment of cost title?
only the cost title in the,
Okay.
yes, Lordship.
With the writ petition? Heard Mr. S.U. Ahmed and counsel for the,
M. Ahmed, Lordship.
sorry, M. Ahmed and counsel for the petitioner, applicant. Also heard Mr. G. Sharma, Learned standing counsel for the empty matters, representing respondent number 2, 4, and 6, as well as Ms. P. Barwa, Learned standing counsel for the respondent number 3, and Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 5. Next. It appears you were in a great hurry after filing of this application, or at the time of filing of this application. This was filed on 12/12.
Yes.
From 12, today is 16.
16.
You are very busy running here and there, is it? You are asking for amendment of the cost title, and what would happen to your affidavit? In your affidavit, again, there is Shampur in the writ petition.
Oh, yes.
Now, what would happen? Okay. That's and Mr. P. Sharma, then Ms. Barwa is for 3, and Mr. P. Sharma, additional senior government advocate for respondent 5. Next, by filing this interlocutory application, the applicant projects that the place of residence of the applicant, who is the writ petitioner in WBC 6383 of 2024, is not under police station Shampur, SHYAMPUR, but it is within the jurisdiction of Harupetia Police Station. So according to prayer for amendment of the cost title of the connected writ petition is made. Next, the application stands allowed. The applicant is permitted to amend the cost title in respect of the applicant in the connected writ petition by submitting specially typed cost title to the AOJ FT section within 2 working days for incorporation in the cost title. Next para, as the affidavit in support of the writ petition corrects the incorrect police station, the applicant, the court permits the applicant to file a fresh affidavit in support of the connected writ petition, which will be incorporated in the record as page 28 within bracket A. Most of the earlier affidavit shall remain on record at page 28. That's where this application stands disposed of.
Lordship, I have not appeared till now, Lordship, because I was sent because of that mistake in the PS, Lordship, they have not accepted my application there, Lordship, before the S1. So I will appear again, Lordship.
Accordingly, time for the applicant to appear before the Superintendent of Police border at Mongolzori stands extended by 10 days from today. The expiring the event the applicant appears before the said authority within the extended time, the said authority shall do the needful in terms of the order dated 4/12/2024 passed in the connected WPC 6383 of 2024. Next, this order shall be read together with order dated 4/12/2024 passed in WPC 6383 of 2024. Application stands allowed.
Item 1 for motion.
Lordship. This is an ex parte order, Lordships. And ex parte order is at page 14, annexer 1. Lordship, here, as per the
Just a moment.
reference,
Just a moment. Daniel.
Lordship, as per the reference,
Just a moment.
my name is written as should.
Please wait for some time. This third time I'm telling you.
Problem. Lordship.
No, we understand, but please pay attention. We are telling you sometime. For third time, we are telling you.
Lordship.
If I shout loudly, then you will say that the
Lordship.
judge is disrespectful to the bar.
Okay.
Correct. I speak softly, then please be attentive. We accept, you have some difficulties, we accept it, but please pay some attention. Mr. Sharma,
Lordship.
when the petitioner claims that she is the resident of the same village,
Yes, Lord.
we'll have to allow it because even here she's claiming to be the village is a resident of the same village, Kasimpur. She must get an opportunity of contesting the matter.
Lordship may allow it. In para 6, Lordship, page 15, it was tribunal discussed everything. Okay.
But she's coming and she's
Yes.
accepting that she is the resident of the same village. We are allowing her application.
Yes.
Heard Mr. S.C. Pandit and the counsel for the petitioner. Also heard Mr. G. Sharma and standing counsel for the FT matters representing respondent numbers 2 and 3. And Mr. P. Sharma and an additional senior government advocate for respondent number 4. And Mr. A.I. Ali and a standing counsel for respondent number 5. Next one. Pursuant to order dated 10/5/2024. I said, no, I just say that by filing this writ petition, the petitioner has assailed the ex parte opinion dated 26/7/2019, passed by the learned member, Foreigners Tribunal -1, Nalbari in FT. So and so case number page 14. Thereby declaring the applicant, the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph. The learned counsel for the petitioner has referred to the statement made in the writ petition as well as in the affidavit filed in support of this writ petition to project that the petitioner is a resident. The petitioner, who is the wife of Hasmat Ali, Hasmat Ali, and the daughter of Kitale
As per reference, Kitali Ali, but the actual name is Rajab Ali.
Rajab Ali,
Rajab Ali.
and daughter of what is the spelling?
RAZAB.
RAZAB.
ZAB.
Rajab Ali Ahmed. Was the proceedee in the aforementioned reference case, however, her daughter's name, as her father's name, is reflected as Kitale.
Kitale.
What is the spelling?
Kitale.
Kitale, Kitale, Kitale Ali. It is also projected that the applicant, as the petitioner, is a resident of village Kashimpur, Kashimpur, comma, PO, Kendukuchi, Kendukuchi, under police station, under Nalbari police station in the district of Nalbari, Assam. Post of Hava, as per the process service report, supported by the certificate of the Gambura of village Kashimpur, comma, no such person existed in the village. And accordingly, the notice was shown to be served in a substituted manner in the presence of the village headman. Comma, who had put his signature as witness in the report of the process server, comma, stating that the proceedee has left the said village. Full stop. Next paragraph. The next paragraph, the records received from the tribunal also discloses that as per process service report, comma, the petitioner was not to be found in the village Kashimpur, and the notice was returned to the learned foreigners tribunal. Next paragraph. As the petitioner has now appeared before this court and asserts that she is the resident of village Kashimpur, if her father's name is different than the one reflected in the verification report of the inquiry officer, as well as the reference. Under the circumstances of the court is of the considered opinion that the petitioner should get an opportunity of contesting the proceedings, so as to establish her citizenship and to take an appropriate defense that regarding the name of her father, projected father, who stop. According to the court is inclined to set aside the ex parte opinion dated page 14, dated 26/7/2019, passed by so-and-so in so-and-so, arising out of IMDT case number so-and-so, on a precondition that the petition shall appear before the said learned tribunal within a period of 1 month from the date of this order. Next, it is also provided that in the event the petitioner does not appear before the said learned tribunal, it will be open to the tribunal to pass a fresh opinion by treating the petitioner to be absent on call. Stop. It would not be necessary for the said learned tribunal to issue a fresh notice to the petitioner for appearance in the proceedings. Next one. Till the period of 30 days from the date of this order, comma, it is provided that the petitioner shall not be arrested or deported Next one is applications. This writ petition stands allowed on terms as indicated above. Next for the registry shall send back the records to the learned tribunal expeditiously. Okay, we give you 30 days time to appear. And if you don't appear, then it will be open to the tribunal to pass a fresh opinion, treating you as ex parte. No notice is required to be served to you. For these 30 days, you are under protection, not to be arrested. Yes, item 2.
Thank you, Your Lordship.
14 to 24. Okay, Mr. Sharma, we are giving you protection.
Lordship.
But Ms. T. Begum, learned counsel for the petitioner, also heard. Mr. G. Sharma, learned standing counsel for the FT matters, representing respondent number 2, 4, and 6. And Mr. P. Sharma, learned additional senior committee advocate for respondent number 3, and Ms. P. Barwa, learned standing counsel for respondent number 5. Which page is the opinion?
Page number 31, Lordship.
31.
Yes.
Opinion at page 31. By filing this writ petition under Article 226 of the Constitution of India, opinion dated
14 to
14 to 2024, passed by so and so in so and so. Arising out of reference police case number so and so. Declaring the petitioner, Manwara Beg Khatun, to be a foreigner post 25/3/1971 stream. Notice call for the records. Extra copies within 2 days. Petitioner shall appear before the Superintendent of Police border. Which place?
Borpeta.
Borpeta, within 10 days. Bail of rupees 5,000 with all those conditions, default clause. 10 days time to take bail.
Deeply obliged.
Item 4.
May please, your lordship. My lord, here in this case, my lord,
Opinion of which,
my lord,
which date?
opinion is of
37/24.
37/2024.
Okay, then we'll give you some protection.
My lord. My lord, here in this case, the enquiry was against his father, but declaration has been made against this man and the other family members. So Sudhir Roy case is applicable here. Lordship may call for the records at this stage.
Okay. But Mr. A.R. Sikdar, learned counsel for the petitioner. Also Mr. G. Sharma, learned standing counsel for the FT matters for respondent number 2, 4, and 6. And Mr. P. Sharma, additional senior committee for respondent number 3, and Ms. P. Barwa, standing counsel for respondent number 5. Opinion is which page?
My lord, at page 59 and SR 14.
Page 14. Opinion dated 37/2024, passed by so and so in
59, page 59.
so and so.
59 page only.
Isn't it?
So there are two numbers here in page
Yes,
14.
my lord.
Which is correct one?
My lord, initial number is page 14, page 59 is correct, my lord, but there has been subsequent number that is at page 60.
Oh, which is the right number?
Page
This
60.
opinion in which
Page 60, my lord.
page?
Page 60.
16.
আপনার একটু দেখে নিন। আচ্ছা, দেখাই দিন।
Okay. I'm just writing 1, 2, 3, 4. Huh? There are 4 numbers here. In so and so, arising out so and so, in case number so and so, arising out of IMDT case number so and so, declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next, the learned counsel for the petitioner has submitted that the inquiry was directed against the father of the petitioner, but subsequently the proceedings was initiated against the petitioner and other family members. Next, be there as it may, issue notice. Extra copies within 2 days. Call for the records. The petitioner shall appear before the Superintendent of Police, Border Morigaon, within 10 days and take bail 5,000. With those conditions, default clause, list out of 4 weeks.
DPW.
Forty-six. Yes,
May
please
I
go.
please, Impugn order is at page 32, Lordship.
Page,
32,
your
Lordship.
date is 27/7.
23, Lordship.
23. What is your explanation?
He is in detention camp, Lordship,
Okay. Okay.
and I'm appearing as a legal aid counsel.
Okay.
Lordship, may I-
Your prayer for bail will be considered on receipt of records.
yes, Lordship, but one small, if a short date is fixed soon after vacation, reason is that this morning, the deponent informed me that he is having some eye problem.
Okay.
So for that reason, little urgency is there, Lordship.
Okay. Heard Ms. D. Ghosh, legal aid counsel for the petitioner. Also heard Ms. P. Barba, standing counsel for respondent number 2. Mr. G. Sharma, and it's standing counsel for the FT matters, representing respondent number 3, 5, and 6. And Mr. P. Sharma, learned additional senior government advocate for respondent number 4. Opinion is at page
32, Lordship.
Opinion is at page 32. Opinion dated 27/7/2023, passed by so and so in FT case number so and so, arising out of IMDT case number so and so. I marked it in the order page. Page 32, I have marked it. By declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next para, the learned legal aid counsel has submitted that the petitioner for the petitioner has submitted that the petitioner has been apprehended and he is now lodged in the transit camp, Mathia, Gwalpara. Post of it is also submitted that the petitioner is suffering from some eye ailments and requires urgent medical attention. issue notice. Extra copies within 2 working days. Call for the records. Next, the prayer for bail shall be considered on receipt of the tribunal records. Next, in the meanwhile, the superintendent, transit camp, Matia, Gwalpara shall have the shall do the needful for having an eye checkup of the petitioner. On receipt of a downloaded copy of this order from the learned standing counsel for the FT matters and submit a report to this court. Next para. The registry shall send the requisition for the records through email at the following email address of the learned tribunal. This address, court master will give it to you. Huh? Post of the learned tribunal shall be at liberty to send the scanned copy of the records for being placed before this court. Post of if scanning facility is not available, the said learned tribunal shall take the assistance of the Office of the Superintendent of Police within bracket border Borpeta, is it?
Bojali Lordship.
Bojali.
Bojali.
Next para, list on. Eight, 1/2024. Eight one.
Yes. Deeply obliged Lordship.
Just say another. Both sides are represented. The interlocutory applications shall be considered on receipt of the tribunal's records. List along with the connected definition.
Time being item 3.
Yes, Mr. Roy Chaudhary.
My lord, the judgment is at page 41.
What is the date of the opinion?
My lord, my case is this, my lord, opinion date is, my lord,
18.
18.
Ex parte.
Ex parte, and my lord, the electoral officer has referred the matter of somebody else. I have given the documents, it belongs to somebody else, the electoral officer. And my keen certificate is at page 43. Your lordship will find in the serial number 4, Hanupa Khatun.
Just a moment. Hanufa Khatun.
Khatun.
What is your father's name?
Hazrat Ali. At page 43, your lordship will get.
43.
And the vernacular
Okay.
at page 44.
And how the reference was made?
Reference, my lord, your lordship will find at page 48. Your lordship will find at page 48, this is the electoral officer who has referred the matter. And my lord, on the basis of 2 documents, that is at after paragraph 7. Now, therefore, the matter is forwarded to the SP, illegal migrant,
Page?
page 48. Para 7.
48 and there, which
My lord,
paragraph?
Para 7.
7.
Is forwarded to the SP, question where such a citizen, the following documents on the basis. These are the documents. Local verification of N. Borua, Borpeta, certificate of the president, school certificate. The documents are annexed at page 52. And 54.
Yes, 52.
52 is wife of Abdul Hakim, whereas my husband's name is Asin, the daughter of, and my lord, page 54, your lordship will find Rukia Khatun, Hanufa Khatun, daughter of Jubbar Sonar. Page 54. The vernacular is at page 55. I appeared for some days. I sought for adjournments and ultimately it was rejected and ultimately my lord, it was ex parte. Now they have come to search in search of me now.
Which page is the opinion?
Opinion, my
Page
lord,
41.
page 41. Opinion is at page 42. Last but second paragraph on 12/9/2018, OP was absent.
But you appeared in the tribunal.
I appeared in the tribunal for some days. Then after I, my lord, I sought for adjournment, which was rejected. From bottom, last paragraph, I will say, my lord. On 12/9/18, OP was absent, Learned Cause was
No, but you were
present
given several times.
several times and it was rejected. My lord, I have given in para 15 because when I find in the reference, it belongs to somebody else. Then, my lord, I stopped going over there.
What is the name of your husband?
Husband is Asin Ali.
So the husband's name is correct.
Correct.
My lord, husband name, my lord, in the page 54, your lordship will find the daughter of Jabbar Sanar. My father's name is Hazrat Ali. I will given in the, my lord.
No, but you see, the notice was served on you.
Yes, Lord.
Notice was served, my lord. I appeared. For some days I appeared and sought adjournment. And ultimately, when I found that the reference belongs to somebody else, then I stopped appearing before the court.
You
And
have
it
to
was
consider
passed
your
but-
prayer for bail on receipt of records.
My lord, I am not. I'm at present. I am not arrested, my lord. But they have came in search of me. So, my
But
lord,
your prayer for bail will be considered on receipt of records.
but at this moment, if your lordship gives a stay order, because my lord, on the same facts and circumstances, my lord, our division bench has passed a judgment over this court. This court, my lord, I'm giving that judgment. আমার copy, দুইটা copy পাই আমি। আমার ফোনটা হতে আছে। My lord, in para 8 is the opinion. Here also, my lord, reference was of somebody else. He appeared for some days, then thereafter, my lord. Para 8, my lord, is the ultimate support. My lord, and the guidelines are at para 20, my lord.
No, but in this case, you appeared. The difficulty is that you appeared in the matter and then
But
you
there
stopped
also in
appearing.
that judgment also they appeared, my lord.
No,
The petitioner did not attend the proceedings before the tribunal.
the
petitioner
petitioner claims that
claimed
the
though
only
the
notice
petitioner
was,
received
she received a
notice-
notice from the tribunal. It
notice.
was addressed to so and therefore did not
But
appear.
subsequently realizing the proceedee is not the petitioner accepted the said notice. And at para
Did
3,
not attend. But
the-
in this case, you attended.
my lord, did not attend the proceeding before the tribunal. At para 8, it was stated, my lord, in the aforesaid reason, we are of the view that the ex parte opinion of the tribunal will not be applicable to the petitioner. However, since in view of the
Wait,
confusion,
Mr. Roy Chaudhary, you see, we'll have to examine the records.
my lord, your lordship will call for the records, my lord.
Yes, yes.
The reference and the electoral
The
officers.
only issue is the bail. We'll have to wait for some time for bail.
Because I'm not arrested, my lord, that only I'm praying that if in this moment, my lord. Para 20, the observations are given, my lord. Roman two or three? Three. Roman two. Roman two in para 20. যিটো বেচিছৰ ওপৰত বেছ কৰি যিটো দিছে এইবিলাক চব বেলেগ মানুহ আৰু এইবিলাক হ'লে এইটো পেজ পেজ 48 ইয়াতে লিখিছে কিন্তু ৰেকৰ্ড যিটো দিছে ৰেকৰ্ডটো
Mr. Roy Choudhury will consider a bail on receipt of records. We'll give a short date. We'll have it called on 6th of January.
Well.
Is a Monday.
Well.
Heard Mr. P.K. Roy Choudhury, done at counsel for the petitioner. Also heard Mr. G. Sharma, done at standing counsel for the FT matters, representing respondent number 2, 4, and 6. And Mr. P. Sharma, done as additional senior government advocate for respondent number 3, and Ms. S. T. Khan, learned counsel appearing on behalf of Mr. A.I. Ali, Ms. P. Barwa, standing counsel for respondent number 5. Next paragraph. Petitioner is assailed. By filing this petition as well, so the petitioner has assailed the ex parte opinion dated page 41, dated 27/9/2018, passed by so-and-so in case number so-and-so, arising out of PE number so-and-so, by which she was declared to be a foreigner post 25/3/1971 stream. Next para. The learned counsel for the petitioner has submitted that the petitioner was served with a notice, but her father's name was shown as Abdul Jubbar, Jubbar, Sonar, Sonar, whereas her father's name
page
is
Hazrat Ali, page 43.
43,
43.
is Hazrat Hozrad, Hazrat Ali, of the of village Khudnabari, Khudnabari, Pathar, Pathar, under Kamar Gaon, Kamar Gaon, PS. The police station is which? You have stated here, Kamar Gaon also, and Sarvog also. There can't be two police stations at page 43.
Sarvog, it will be Sarvog.
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 You are sure?
Sure.
It's under Sarvog police station in the district of Barpeta. And therefore, after appearing for a few days, some of the petitioners stopped appearing before the learned tribunal on the, as she found that the proceeding was against a different proceeding. Next part, be that as it may. Issue notice returnable on 6/1/2025. Extra copies within 2 days. Call for the records from the concerned tribunal. To stop the registry shall send the requisition by email to the following email address of the learned tribunal. Address he will give you. First of the learned tribunal shall be at liberty to send the scanned copy of the records to this court for being placed before this court. First off, in the event scanning facility is not available, the learned tribunal shall seek the assistance of the Superintendent of Police, Border, Barbeta, for scanning and sending the said records. In the event physical records cannot be transmitted. Next part, the prayer for interim bail shall be considered on receipt of the tribunal records. Next part, list on 6/1/2025. Just add there, we have recorded the submissions. He submitted so and he submitted that the said case is covered by the decision of this court in the case in the case of Rina Rina Rani Das versus the Union of India and others, comma, within bracket 2021 bracket close 6 GLR 170.
Item 5 for admission.
That will be lordship.
My lord, I am praying 1 week time, my lord, to file an additional affidavit pursuant to the order dated 11/4/2023. I have already collected some materials.
Repeat the same order of 24/7/2024. This is the order. Repeat the same order. First line would be both sides are represented. Okay.
Obliged.
Item 6.
May I please your lordships?
Yes.
My lord, in this matter, the name of the father of the petitioner appears in the voter list of 1965, 71, and 79. 1965 voter list is at page 18, my lord.
Which page is the opinion?
Opinion is at page 26, my lord.
26.
26, my lord.
Just a moment.
Yes. Page 26.
Mr. Sharma,
Lordship.
this has to be remanded back. What a very minor error.
Lord.
This, the evidence is rejected. You see, normally, for a person, male, name would not be Mahima.
Yes, yes.
Mohima is a female name. So in the examination, he says the name of the grandfather is Mohim,
Yes,
but in the typed, he has written everywhere Mohima.
yes.
Mohima is not a normally a
Female.
name of a male. So it is only on that ground that the entire evidence is rejected. 1, 2, and 3 is found to be unreliable.
But Lordship, link certificate was not put, Lordship. Link certificate. Otherwise, Lordship, para 7 of the Indian opinion, page
So
20.
she must get an opportunity of proving it.
Yes.
These things are mistake of the council. They don't know how to, only for that. And tribunal will have a right to only ask clarificatory questions.
Lord.
Here, in the name of examination, the tribunal conducts an entire cross-examination. Is that permissible? Then, where is the cross-examination? Which page?
My lord, cross-examination copy has not
They're
been
not enclosed. This writing, we are finding it difficult. Mr. Sharma, please read this back page of 23. I've we are not finding. No, you read it. We don't want the reading. We only one question. 1965 and 70 were discarded on the ground that the house number has changed, the block number has changed. Correct. Now, is that a question put by the tribunal to this proceeding? That is the only thing we wanted to know.
Order cross examination. You can. Order to both. So that for the 30 minutes. For the 30 minutes.
He was not cross-examined. He was not cross-examined, Lordship. Here it was answer to some queries of the court by the
court, yes.
court.
So that was never brought to the notice. I think it must be remanded. She must get an opportunity to establish that. Anything specific you wanted to point out?
No, my lord.
Because there's also one more thing. Age difference is there.
Age difference in the voter list, my lord. Normally, what at that point of time, the people come and they normally do not visit the every house, my lord. They don't go to every house, my lord. From the headman or the Gaubura, my lord, they take the data and just put some approximate age, my lord. And what happened regarding the non-proofing of the document, the linkage document, because it is at the initial stage of the FT matters, my lord. At that point of time, most of these documents were not duly proved as in the matter it was to be proved. Now, my lord, the documents are proved, my lord. But at that point of time, my lord, documents were exhibited, but it was not proved. So if your lordship pleases to grant an opportunity, my lord.
Just a minute.
Otherwise, my lord, on the prima facie, my lord, it seems that, my lord, because the voter list, the voting center, police station, other things are same, my lord. 65, 71, 79 voter list, my lord.
But why there's a change in block number? Are you aware?
Place is also changing, Lordship. Village is also changing.
No, village from 75 to 65 to 71, there is a change of their residence, my lord. And it has been pleaded in my petition also, in the nearby village, my lord. And probably in the question also, my lord, the questions put. The questions put to the petitioner, there is a mention that her father expired in a rented house, my lord.
You have annexed your written statement.
No, my lord, written statement is not.
Written statement you have to decide on it. Okay.
In the written statement, is that statement made about shifting?
No, no, Lordship. Not mentioned, Lordship. Lordship, may I read the WS, Lordship?
Hmm?
May I read, Lordship, WS?
No, just be satisfied with that. We take your word for it.
It's not mentioned in the WS, Lordship, and Lord.
And the tribunal also did not ask questions about shifting.
Yes, Lord.
Asked? No.
Not asked.
Not asked. Then we remand the matter back. The tribunal cannot take up cross-examination. get an opportunity. We'll take a short break and come back. Yes. Heard. Mr. D.P. Bora, learned counsel for the petitioner, also heard Mr. G. Sharma, learned standing counsel for the FT matters, representing respondent numbers 2, 3, and 5, and Mr. P. Sharma, learned additional senior government advocate for respondent number 4. Next para. Page 26 is the opinion. By opinion, the filing of the petition number so the petitioner has received the opinion dated 30/3/2017, passed by so and so in FT case number so and so, arising out of SP case number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next para. Just pass on that record.
Yes, Lordship. He was not, otherwise he was not cross-examined, Lordship. It is
Okay,
only
we saw that. That's
Yes,
why.
Lordship. And that was not also mentioned in the order also, Lordship. And Lordship, apart from that, Lordship, otherwise there was no link at all, Lordship, to establish her link with her projected father, Lordship.
We agree that.
Yes, Lordship.
You see, we agree to what you were saying.
Yes, Lordship.
But the fact is that if there is a certificate, they are in the hands of lawyers who don't know how to prove documents. So that let an opportunity be given. After that, if she could not sustain that, then declare her to be a foreigner.
Tribunal will reappreciate the evidence available on record, Lordship.
Hmm?
That must be. Tribunal will reappreciate the evidence
Ah, yes, yes, it's not a-
available on record, Lordship.
Yes.
Nothing apart from that.
On receipt of notice of the proceedings, the petitioner appeared before the learned tribunal and had filed a written statement on the first date of appearance, i.e. 25/11/2016, and on the next date of the proceedings, which was fixed on 22/12/2016, she has filed her evidence on affidavit and she has exhibited 7 documents, certified copy of voters list of 1965 within bracket exhibit 1 ext sub 1 bracket close, certified copy of voter list of 1971 within bracket exhibit 2, certified copy of voters list of 1979 within bracket exhibit 3, copy of NRC of 1965 within bracket exhibit 4, a certificate dated 22/6/2015 issued by the President and Secretary of Jaluguti, JALUGUTI, Gaon Panchayat, containing counter signature of circle officer within bracket exhibit 5, certificate dated 28/11/2016, issued by the Ward Commissioner, Lanka Municipal Board, Ward number 7, within bracket exhibit 6, and voters list of 19, a certified copy of voters list of 1989 within bracket exhibit 7, and a affidavit to explain, affidavit of the petitioner to explain the discrepancy of name of a father within bracket. Also, we give a date dated 22/12/2016, within bracket exhibit 8. This affidavit you like sworn on 22/12/2016. Within bracket exhibit 8. Full stop. Next, para the learned tribunal. After appreciation of the evidence on record, it may be mentioned that that as per the record, the learned member, Foreigners Tribunal, Lanka, had asked questions to the petitioner, which is recorded on 6/1/2017. Purportedly as the government leader was absent. Next para, the learned tribunal, upon discussing the evidence on record, discarded exhibit numbers 1, 2, and 3, being the certified copies of voter list of 1965, 1971, and 1979. On the ground that the house number and the block numbers were not matching. And the learned tribunal took note of the fact that during the period from 1965 to 1971, no door-to-door enumeration was carried out. Moreover, the learned tribunal also found discrepancy in the age of the father on comparison of the age reflected in exhibit 1 and exhibit 2. Stop. The voter list of 1971 was within bracket exhibit 3 was discarded on the ground that the name of petitioner's grandfather was recorded as Mahima. Whereas during examination by the learned tribunal, she had stated the name of grandfather as Mohim. Mohim Muzumdar, Majumdar. The LRC of 1965 within bracket exhibit 4 were discarded as the same was a downloaded copy and had no evidentiary value either as a primary or a secondary evidence. Exhibit 5 and 6 were discarded as the said two certificates were not proved in accordance with the law laid down in the case of Life Insurance Corporation of India versus Ram Nexpert Pal PL Nexpert Singh, comma, within bracket 2010 bracket close 4 SCC 491. And accordingly, it was held that the said documents were of no help to support the linkage of the petitioner with citizenship, Indian citizenship status. Post of Exhibit 7, which is the voters list of 1989, was discarded in light of discussion on exhibit numbers 1, 2, and 3. Post of the affidavit within bracket Exhibit 8 was also discarded, that it was a self-supporting affidavit. Accordingly, the petitioner was declared to be a foreigner. Next para. The learned counsel for the petitioner has made his submissions that to the effect that the minor discrepancies in the in reference to the block numbers was the ground for discarding exhibit numbers 1 and 2, as well as with regard to discrepancy in the age of petitioner's father. And then exhibit 3 was discarded on the discrepancy in the name of the grandfather of the petitioner. Which could not have been a ground for discarding the said exhibits and to declare the petitioner to be a foreigner. It is also submitted that the petitioner had produced exhibit number 5 and 6, which was not proved in accordance with law. And therefore, an opportunity should be granted to the petitioner to prove a linkage to have parents who were projected parents who are claimed to be citizens of India. Next para. Per contract, the learned standing counsel for the active matters has made a submission in support of the impugned opinion, and it is submitted that as the documents exhibited by the petitioner does not establish a linkage to a projected parents and grandparents. Opinion impugned in this petition warrants no interference. Next para. Consider the submissions, has also examined the records received from the learned tribunal. Stop. It is observed that on 6/1 2017, in the absence of the government leader, the learned tribunal had asked questions to the petitioner which is recorded in the back page of the of page 1 of the evidence on affidavit. First of all, having read the examination by the learned tribunal, called the records were handed over to the learned standing counsel for the FT matters to examine if any of the grounds on which the evidence of the documentary evidence of the petitioner were discarded were put to the petitioner. Full stop. However, on the perusal of the said examination, neither this court nor the learned standing counsel for the FT matters could find any circumstances relating to exhibit numbers 1 to 8 were asked the petitioner post. Next para. The learned tribunal has recorded that during the period of 1965 to 1971, no door-to-door enumeration was carried out. Full stop. To support this said finding, no one from the concerned authorities were examined by the learned tribunal. Full stop. The petitioner was not also put any question to explain why there was a change in the block numbers or in respect of the voter list of 1965 and 1971. As per the opinion, as per para 6 of the opinion, exhibit 4 is stated to be the downloaded copy of voters list of 1965, whereas as per the record of the learned tribunal, exhibit 4 is the document marked as exhibit 4 is the copy of NRC of 1965. Therefore, the court is of the considered opinion that the as the tribunal had, as the learned member, foreigners tribunal, Nagaon, number 7th at Lanka, had examined the petitioner instead of being cross-examined by the government leader. And in the order sheet of 6/1/2017, the learned tribunal has recorded that it had examined the petitioner in the absence of Due to the absence of the court is recorded that the tribunal had put questions to the petitioner which he answered on oath in the absence of his of the government pleader, comma. It prima facie appears that the learned tribunal had substituted itself to ask questions in lieu of the government pleader. Full stop. None of the questions asked were clarificatory in nature. Full stop. Moreover, comma, in view of incorrect appreciation of Exhibit 4, which as per paragraph 6 of the evidence on affidavit is the copy of NRC, which corresponds, and the exhibit, and the document marked as Exhibit 4 corresponds to the NRC of 1965, which was appreciated as the voters list of 1965, the court is of the considered opinion that the impugn opinion is not sustainable on facts and in law. Next, presentability, what has no hesitation, to set aside the impugn opinion dated 30/3/2017, passed by so and so and so and so. Consequently, the matter stands remanded back to the learned tribunal for a fresh decision in accordance with law. Next paragraph. The matters demanded for adjudication by the said learned tribunal in accordance with law. Next paragraph. The petitioner is directed to appear before the learned member, foreigners tribunal, Nagaon number 7th at Lanka, within a period of 30 days without waiting for any fresh notice from the said learned tribunal. Stop. By producing a certified copy of this order, the petitioner shall seek further instructions from the said learned tribunal. Next paragraph. For this 30 days time allowed for the petitioner to appear before the learned tribunal. She shall not be arrested or deported out of the country. Full stop. Next paragraph. However, it is provided that in the event the petitioner does not appear before the learned tribunal within the time allowed, it would be open to the tribunal to pass up fresh opinions based on the materials available on law, treating the petitioner to be absent on call and it would be permissible for the said learned tribunal to pass an ex parte opinion. Next part. The registry shall send back the records expeditiously. So the representation stands allowed to the extent as indicated above.
Deeply applied.
30 days time to appear,
Yes, my lord.
failing which we will proceed ex parte.
Yes,
Sitting as well, no further notice.
yes, my lord. Deeply applied.
Item 7.
If item 7, the brief petition was filed by the state lordship.
Pardon me?
Lordship, against the opinion of the learned ST1 Borpeta lordship.
Yes.
Lordship, I need some time, lordship, for better preparation, lordship.
Okay.
Immediately after vacation, lordship. if it's-
17 matter.
Yes, I
You
know.
understand that,
Earlier taken adjournment also.
Immediately
understand,
after vacation,
but-
lordship, that may be fixed.
but
lordship.
Mr. Sikdar, you should not have been studying the records here. You are going through the records here.
Gone through the record.
That is why he had to take time. You should not have done it. You are in indeed protection.
Well,
Okay.
Well, there is a stay against the impugned judgment. They-
Okay.
Declared not for enough.
Okay, it is stayed.
My lord.
Okay. Both sides are represented. On the prayer made by Mr. G. Sharma, done at standing counsel for the FT matters, or the matters stands adjourned today. List after ensuing winter vacation on a date to be fixed by the office. Registry.
Lordship, one date may be fixed.
I'm not
lordship,
giving a
but-
date because it's become, because you see, we are giving dates on those cases where we are not given bail.
Yes.
So therefore, the entire system will clog up. So therefore, we're not giving a date. Because fixed date matters are required to be listed. So this vacation period, we are not giving a fixed date unless necessary. Make a mention if required.
Yes, lordship.
Item 8. Here the counsel of the petitioner has expired. So NN Karmakar.
Yes, lordship. Figurehead council may be appointed, lordship.
No, the report has not come. I think you have to get a report as to whether the court notice was served. Or should I pass a fresh order? You see this order, you see this order, Mr. Daniel. With the previous order.
Yes, lordship. Lordship. If required, Lordship, through SP Lordship, I
The
can.
previous order is there. Yes.
Yes, Lordship.
When you get the information, or we should pass a fresh
No,
order?
Lordship.
Fresh order?
Yes, Lordship.
Okay. There's no representation from the petitioner. First, however, comma, all the respondents are represented. Next para. The by order dated 17/5/2024, comma, this court had taken notice of the fact that the counsel for the petitioner has expired, and accordingly, the through the Supreme Police, comma, border, sorry, to Supreme Police within bracket border, comma, Chirang at Kajulgaon, and the officer in charge of Panbari Police Station, comma, the registry was directed to inform the petitioner or the same and to do the needful. Full stop. The report of service is not yet received. Next para. Accordingly, the petitioner, namely H2, namely so and so, son of so and so, is put to notice that his earlier counsel, late N.N. Karmakar, has expired. So as to enable the petitioner to engage another set of counsel in this matter. Next para. In order to expedite service, comma, the court is inclined to direct Mr. G. Sharma on a standing counsel for the FT matters to send a downloaded copy of this order to the Superintendent of Police within bracket border bracket was Chirang at Kajilgaon, so as to enable the said authority to communicate this order to the petitioner through the officer in charge of Bijni Police Station. Full stop. Upon service. अच्छा, okay, police station. Upon service of the download copy of this order to the petitioner, comma, so report of service shall be sent to the court through the learned standing counsel for the FT matters. Next paragraph. The notice is made returnable on 22/1/2024. List accordingly. Basically, should I give him a copy of this order? Copy of this order, you give it to Mr. Sharma. Item 9. Which page is the opinion?
And opinion page 48, my lord.
48. Where is your written statement? In your written statement, have you referred to your brother who
No,
appeared as DW2?
no, my lord, it is on evidence, my lord.
Your
Instrument on page 36, my lord.
where is this exhibit E? Jawabandi
The Jawabandi is start from page 24, my lord.
20,
4, my lord.
24. And this Jawabandi, which is the entry of your father,
My lord, first one, my lord.
Hazrat Sheikh,
Hasmut Sheikh, my lord.
Asmat Sheikh. Huh? What is the name of your brother? DW2.
My lord, brother name is Abdul Malik, my lord.
Abdul
Malik.
Malik. Is his name entered here?
No, my lord.
Then there's no link. What is the wrong in the tribunal's opinion? Your father is alive. That
No, my lord,
means
father expired.
then your name of your brother is not, and your name is not mutated in respect of the land. So therefore, there is no connection. What is wrong with the order?
But my lord,
Your name is not introduced in the evidence. Your own identity is not proved. You did not exhibit your own identity. Your name does not appear in any of the voters list exhibit.
my lord, Bhutan is also not exhibited
Huh?
during that total list was not exhibited, my lord.
Then there's no connected. We don't find anything wrong in this opinion.
My lord, one opportunity may given, my lord.
No, but it can't be for asking. We'll have to, without an introduction of anything. Because we cannot substitute our opinion with that of the tribunal unless we find an overwhelming case. In the last case, we found that then exhibit was wrongly mentioned, which gave us a ground to send it back. Here we are not finding anything. What are the documents exhibited?
My lord, total list in respect of his father, her father, my lord. One total list, my lord, only in 1965, my lord. That is on page,
Where is the evidence?
evidence of DW1 is page, start from page 40, my lord, 40.
40. In your deposition, no document is recorded.
Documents exhibited by her father, brother, my lord.
By her brother.
By, yes, my lord.
We'll continue after lunch, but you've not been able to show anything. The name of your father is different. Your name of your husband is also different. Because now you are coming and saying that your name of your husband is Abul alias Abu Bakr. But look at page 37. Wife of Abu Bakr Siddiq. Abul was not even there. You have not proved anything. Come to page 36.
My lord.
Second paragraph, page 36. Here you show the name of your father is Hasmat Ali. The land documents which your purported brother came and proved is Mohammed Hasmat Sheikh. You don't find anything in your case. We'll continue at lunch or post lunch.
Item 19, my lord.
Just tell the court master.
Lordship.
Hmm. You're there in this matter.
My name not.
Okay. On whose instructions you are appearing?
K law for my lord.
Okay. You see, you should have told us earlier that you are not the counsel on record.
I'm sorry.
Because if you pass an order and if it goes in your favor, that is okay. And if what happens if it goes against you? Then you are not the Wakalatnama holder on record. No, these things you should tell us in advance.
I'm sorry, my lord.
You see the consequences.
My lord.
If you succeed, then it is okay. But what happens if you don't succeed? Then what happens? You take the responsibility of that. Are you ready to, are you prepared to take the responsibility?
Sorry.
Tell us yes or no. Not sorry is not the answer. Are you willing to take the responsibility?
No.
Then you should have told us earlier. It's a minimum courtesy you should have to show to the court. Okay. As the counsel for the petitioner is absent on call, matter stands adjourned today. All the respondents are represented. You see, we have spent half an hour of time.
My lord. Apologies.
After half an hour, then while dictating the order, we check the Vakratama, you are not there, so we have to ask you. Don't do that. You'll be trouble. You'll be in trouble, real trouble sometime. Every time you will not be so lenient. You may be in deep trouble sometime. Okay. We had gone the matter. Mr. Chaudhary, we had asked for upgradation of the order of the matter. Yes, Mr. Chaudhary, your request was made to upgrade your matter.
I am grateful. Your worship will recall my that the appellant before also challenged the promotion of the respondent number 7. And that challenge has been, my lord, rejected by the honorable single judge. And the grounds which are
Just a moment, the file is not this. Just a moment. Oh, need to wait for some time. The records are not located. Just wait. Just wait for some reason. The records are not located. After some time, the files have not been located. Item 10.
My lord,
Which page is the opinion?
opinion, my lord, page 36. Abortive portion is starts from page 37.
Yes, Mr. Mahmood.
My lord. Actually, so far the documents are concerned, my lord. I have a good case, but my lord, from my understanding, my lord, I understand that case is not properly conducted. For instance, my lord, voter list of 1966 is annexed. And
Yes.
1966 voter list, my father's name is Abdul Ali,
Yes,
and his name appears in the voter list of 1966.
yes,
That lordship may kindly see page 12
yes,
and vernacular page 13. Abdul Ali, A. Ali, and my grandfather is Matab Ali, Sobo. My father is Sobo. Sobo, Sobo Sheikh, but it is shortened in Sobo. Similarly, lordship may kindly see page 14. My father's name is A. Ali, son of Sobo. So these are the vital documents I am having. Then lordship would kindly see page 16. That is the voter list of 1997. My name is with my husband, Hussein Ali. I am Fulbhanu, wife of Hussein Ali. So before, after 70, she was married and her name has been recorded with the voter list. And my lord, similarly, page 17.
Just a moment. Yes,
Page 17 is the vernacular. So where my name appears along with my husband. Similarly, my lord, page 18 is the voter list of 2010. My name appears with my husband, Hussein Ali.
just a moment. Something is wrong. Something is wrong here. You have the records with you?
Records are there, my lord.
I mean, records.
Evidence, my lord, I could not annex because at that time it was not given. No till to date is given, but it is on record, my lord. From record, it appears there are evidence of the petitioner, that is the proceeding, and his brother Nur Islam. Their depositions are same. Nur Islam is the own brother of petitioner. And they use the same legacy data during the NRC process. And this Nur Islam clearly said that she is my sister. And Fulwanu said in her evidence that Nur Islam is my brother. So in that way, my lord, their link is there.
First look at the order sheet and then look at page 7 and 8 of the record. Look at the order sheet first. Obviously, your officers are not here. Home Department officials are not here. Correct. They have every reason not to be here. Look, this is how you are proceeding. No point hearing this matters, has to be remanded back. The entire exercise is only for newspapers. Tell the people that the issue of foreigners are alive. Nobody wants in the government. How does he say that it's not proved? Tribunal will reappreciate evidence and pass fresh orders. You don't have to say anything more. This is one of the worst case. Mr. Mahmood is saying that it is a good case. It's a worst case which he has. But
Process is going on, Lordship.
no, nothing is going on. Otherwise, your officers would have been here. We have passed judicial orders for your officers of the Home Department to be present in court proceedings. You are not producing them. They are hiding under the blanket. They think that if they are under the blanket or under the bed, they are safe. Just like when we were small kids playing hide and seek here and there. We are behaving like a 3-year-old child. Your officers in the Home Department. They are just hiding behind the tree or under the bed. And they think they are safe. Nobody can find them out.
My telephone instruction, immediately they will arrange some training programs.
No, nobody is interested. Section 9 burden is only on the 2 honorable judges. You don't have to say anything more. Heard Mr. M.U. Mahmood Taner. This person. Heard Sami Mahmood and counsel for the petitioner. Also heard Mr. G. Sharma, and standing counsel for the FT matters representing respondent number 2, 4, and 5, and Mr. P. Sharma, Leonard, and Mr. S.K. Hazarika, Leonard, government advocate, appearing for respondent number 3. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed. The petitioner, namely so and so, has assailed the opinion dated page 36, 30/10/2017, passed by so and so in so and so, by declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph. On a perusal of records, it is seen from the order sheet that during the proceedings of FT within bracket 5th bracket close case number 788 of 2016, the government pleader was absent. Full stop. After filing of the written statement, the tribunal took up the role of examining the petitioner and a witness who presented themselves as DW1 and DW2. Full stop. There is no cross-examination of the no, not cross. In the absence of GP, the petitioner and her brother were examined. Now, their examination in chief was recorded in the absence of the government pleader as DW1 and DW2. So, though there were no cross-examination by the government pleader appearing for the state. Full stop. However, in the opinion, the learned tribunal has discarded the exhibits, comma, being voters list of 1966 within bracket exhibit 1, comma, voters list of 1970 within bracket exhibit B 2, NRC claimed to be in the name of the projected father of the petitioner as of 1966 and 1970 as exhibit 3 and 4, comma, epic of the petitioner within bracket exhibit 5, voters list of 2011 within bracket exhibit 6, comma, epic of DW2 within bracket exhibit 7, Gambra certificate within bracket exhibit 8, legacy data of the petitioner's projected father of legacy data of 1966 of the petitioner's projected father within bracket exhibit 9 and exhibit 10. Stop. In the absence of any cross-examination, comma, the tribunal discarded the said exhibit numbers 5 and 6 on the ground of age discrepancy and that the name of the mother did not tally in what is this of 1970 within bracket exhibit 2, and NRC form within bracket exhibit 9. And it was held that the petitioner has failed to prove a burden. Next para. It is true that the burden of proving that the petitioner is a citizen of India is on the petitioner under section 9 of the However, when the petitioner is DW1 and our brother is, and a projected brother is DW2, not cross-examined by the state, it cannot be said that the petitioner has failed to discharge a burden of proof. Full stop. In the present case, the tribunal also did not exercise its power to put clarificatory questions to the petitioner if certain discrepancies were found. Under the circumstances, the court is of the considered opinion that the impugned opinion is not sustainable on facts and in law. So accordingly, the court has no hesitation to set aside the opinion dated 30/10/2017 passed by the learned member, Foreigners Tribunal 5th, Darang Mangalde in so and so, page 36. Accordingly, the matter is remanded back to the said learned tribunal for a fresh decision. Stop. It will be open to the state respondents to take a call as to whether they want to participate in the proceedings or not. Next paragraph. The petitioner is directed to appear before the learned member, Foreigners Tribunal 5th, Darang Mangalde, within a period of 30 days from the date of this order. And on appearance of the petitioner, the learned tribunal shall pass a fresh opinion in accordance with law. Next paragraph. In the event the petitioner does not appear before the said learned tribunal within the time allowed, it would be open to the learned tribunal to treat the petitioner as absent on call and pass ex parte opinion. So that to appear before the 30 days shall be without waiting for any notice to be issued by the learned tribunal. Next, for this 30 days, it is provided that the petitioner shall not be arrested or deported. For 30 days from the date of this order, shall not be deported or deported. Next, the records of the tribunal be sent back. Representations are allowed to the extent as indicated above.
Next, humble prayer. There are only 2 witnesses have been adduced.
No, we are not saying anything. You are left open. We are just remanding the matter back. You take your call. Because we cannot give you a liberty which is otherwise not paid for. And in the in exercise of this jurisdiction of surgery, we cannot direct the tribunal to do like in a particular manner. It is for you to take it.
All right.
Upgraded item 51.
Junior Information Officer.
Promotion to the post of Junior Information Officer. Appellant before your lordship is a librarian and the private respondent is a translator.
Yes.
The case of the appellant before the Honorable Single Judge was that under the rules, the post of translator is not a feeder cadre, not a feeder post, and therefore the respondent number 7 could
You
not
are
have been.
referring to Rule 9 and Rule 9(5).
My lord. Rule 11.2, my lord, particularly.
11.25.
11(2).
Right.
You give us a copy of that.
Yes, my lord. We have provided that's a part of the record also, but for your lordship convenience, my lord, we'll.
When it comes to jump from foreigners to service law, there's a sudden loss of energy.
But then that may be, my lord, a great relief also.
We have it.
Rule 11 provides for promotion. Thank you. The relevant clause is 11 sub-rule 2 Roman 5.
You remember, I'm just changing for the changing of the mind, what you call changeover for the mind. I'm just digressing from, you have seen this video account. In Chennai, there was a airport.
My lord, my lord.
I said, I saw this video.
No, I have not seen that. Yes. Yes. Yes.
So he lies at the narration he gave me about the technical aspects of it. So that
Yes, maybe there can be a view that it could have landed and that would have been safer. We are in safe hands, my lord.
So this was only for a changeover
My lord.
to bring us back to this service matter. Yes.
My lord, sub-rule Roman 5 is at page 10, internal page 10. The rule 11 starts at internal page 9.
Yes.
1 and 2, they relate to the vacancies in the other cadres. And then sub-rule 5 is, my lord, the feeder cadres are journalist, sub-editor.
Translators does not have the avenue of promotion. That's what you said.
Yes,
Hmm.
that is one. And my lord, so far as the cadre is concerned, because that cadre word will be important, my lord, because of the findings of the honorable single judge. Rule 3, if your lordship kindly comes to at page 2, these are the class, cadre and status. There, my lord, class 1, class 2, and class 3. Class 3 includes junior information officer. That means that is the post, my lord, we are vying for. My lord, the cadre stands, my lord, ends there. So, my lord, these posts.
9.5.
My lord.
9.5.
No, my lord, three, my lord, rule three,
Rule 3.
my lord. Page 2,
Ah,
class
yes.
and cadres and status.
Class 3.
Class 3, my lord, class 3 is the junior, includes my lord, junior information officer, the post, my lord, we are vying for. So, my lord, the cadre and class and status, so far as the rules are concerned, my lord, it ends there in class 3. Now, the honorable single judge rejected the contention of the appellant.
So the encadrement
Right.
starts from class 3.
Yes, ma'am.
Okay. Yes.
The honorable single judge might have rejected the contention of the appellants on the ground that, firstly, my lord, that the authorities have power to include any post in any cadre, and that government has taken a decision to include the post of translator in the, my lord, these feeder cadre posts. That is first ground.
Because the
And-
government has reserved upon it to have that equivalent.
Yes, my lord. The honorable single judge, my lord, relied on the
Rule 26, power to relax.
my lord,
Power to relax is 26.
not power to relax, my lord. Rule 3 to B, your lordship will kindly come after the class 3, my lord, your lordship will find rule 3, sub rule 2. The service
May
may
also include any post equivalent to a post in any cadre mentioned in Rule 1.
and B,
Any cadre.
cadre or post laid down by the government to be included in the cadre of the service.
Service. Okay.
Now, my lord, this is the rule the honorable single judge has granted. I'll make submission on that, my lord, because this sub rule B of sub rule 2 cannot be read in isolation. And my lord, this is to be included in cadre of service because, my lord, the post of neither the post of librarian or translator is in the cadre. Now, this is one ground. The honorable single judge has said that government has already taken a decision to include the post of translator in the feeder cadre, which is, my lord, absolutely wrong on facts, my lord. And the second ground is that, my lord, it is a
Can you refer to that part of the
judgment, my lord.
judgment?
Yes, my lord. I am coming to that, my lord. There are two findings. One is regarding that it has already been encouraged.
Yes.
Or, my lord, included. The other is that there has been a past practice of promoting the translators. These are the two grounds on which the my lord, the petition was rejected.
Yes.
Now, the finding.
There are two findings so that we can alongside write.
Yes, my lord.
In the note.
The finding, your lordship, will come at page 307, paragraph 31. So far as the first finding on facts is concerned. Page 307.
Yes.
Paragraph 31. It further appears from the letters dated 21/9/1994 that since the scale of pay of the post of translator is equivalent to the post of journalist, sub-editor, proofreader, and librarian, the same are being clubbed together under Rule 11.2.5 of 1986 rules. Thus, it appears that the government of Assam, by way of an executive instruction, has taken the decision to anchor the post of translator and club the same with the post of journalist, sub-editor, proofreader, and librarian, which are anchored feeder posts for promotion to the post of junior information officer. It further appears that the government has also decided that the appointment of translator shall be guided by 1986 rules and that no separate service rules is necessary in that regard. Apparent that the power of the state government to take the post of translator to be included along with the feeder posts in the 1986 rules is provided under Rule 3.2b of 1986 rules. Hence, the action of the state respondents in promoting the respondent number 7, who is holding the post of translator to the post of junior information officer, appears to be in conformity with the 1986 rules. Now, my lord, this finding is based on two communications. Those communications have been quoted, my lord, in the judgment itself. First, your lordship may come to page 304, paragraph 28. Two communications have been referred to by which, my lord, relying on which the Honorable Single has said that government has already taken a decision to include the post. Paragraph 28. Two communications, one dated 16/8/1994 and the other is dated 21/9/1994. Those have been quoted, my lord, in the judgment itself. May I read it, my lord?
এডমিনে কৰিব লাগে আৰু এটা পোষ্ট খালি ৰাখিব লাগে হা ক'ব লাগিব কি থাকিব বস্তু ভেকেণ্ট ৰাখিব সেইটো কাৰণে সেইটো কাৰণে শুনি আছো নেকি
Now, these two communications, your lordship will see the first one is 16/8/1994. This is a communication from the Director of Information and Public Relations to the, my lord, government, Deputy Secretary of Government of Assam Home Department. In inviting a reference to the letter on the subject quoted above, subject is encadrement of translator. On the subject quoted above, I have the honor to state that the posts of translator of this directorate were created and permanently retained by the government. As such, the proposed encadrement of translator may perhaps be made by the government. Moreover, it is requested kindly to enlighten this director will be the appointing authority in respect of posts of translators in Finance Department. This is,
But
my
it's-
lord, only a proposal from the director.
No. No, he wants enlightenment. This is not even a proposal.
It's not
It is
a-
only a letter seeking enlightenment.
My lord.
Correct. Now, I did not understand this para 2, the post of translators in the finance budget department. How is finance budget related to information and public relation?
My lord, that is what the director, my lord, the director was, my lord. A little
No, why would
over-
the director be interested in finance budget department?
It cannot be, my lord. But this is the document, my lord, on which the Honorable Single Judge relied. And the other one, my lord, follows thereafter in paragraph 30. The later
In
dated,
regard framing of services of non-gazetted post and director information, it is are grouped into information assets, assistance,
my lord.
and these are substantive posts in the. There's a provision for the motion. Okay.
Then, my lord, next communication is also, my lord, another communication by the director. Paragraph 30, my lord. From the director to the, my lord, Deputy Secretary, Government of Assam, subject encadrement of translator. With reference to your letter on the subject cited above, I furnish below the following required clarification. Implementation of the recommendation of the pay commission for so-and-so translator with the public relation department is feasible. The scale of pay of the translator of finance department and that of this department
Wait,
is
something
same,
is wrong again.
my lord. Anyway, my lord, now we are not concerned with A, we are concerned with B.
No. Because this is, these two are unconnected. Para 28 and para 30 are unconnected.
But the subject is same, my lord, encadrement of translator.
No, because you see, come to page 304, para 28,
My lord,
the letter is 16/8/1994,
my lord.
correct?
Hmm.
Now 306 is 19/9/90.
21/9.
No. Reference is your letter number so-and-so dated 19/9/94.
That is, my lord, some other reference, my lord, not with reference. to
Not with
this here.
reference to this.
Not with reference to this.
Okay.
163.
Yes.
Then, my lord, B, Non-implementation of the recommendation of the pay commission after getting no objection from administrative department is primarily due to formal notification from administrative department encouraging the translator of finance budget department with the public relation department has not yet been issued, and the departmental committee constituted by the government to appoint non-gazetted employees in the department has no power to select candidates. Now, this is my lord a procedural requirement.
No, Mr. Chaudhary, this, we are not being able to follow this paragraph A.
Yeah.
Implementation of the recommendation of pay commission for encouragement of translator of the finance budget department.
No.
Again, this finance budget is coming in. How is it related to Director of Information and Public Relations?
Perhaps, my lord, an analogy was sought to be drawn that, my lord, the finance department, the translators are, my lord, encountered. Then, my lord, the translators in the information department, the IPR also can be included. Because there is no reason otherwise, my lord, for the director, the IPR, to be concerned about what is happening in finance budget department.
So you see, that's why we are asking this. Now C is the answer. Page 306, para C. ROP rules so-and-so has suggested encardment of translator in the finance budget only.
Not
They
in
put-
this my lord, department.
Not in the other department.
No, my lord, in order to get this, because my lord, these are the two letters based on which the, my lord, the honorable single judge has held that, my lord, the government has already taken a decision. In fact, my lord, the honorable court passed an order directing the authorities, my lord, to place on record as to whether any decision has been taken. That order, my lord, two orders, if your lordship permits me, I can, my lord, I may produce it. One order dated 26/9/2024, and the other is 22/10/2024. Because, my lord, apparently, my lord, the court took the view that there was a proposal, and what has happened to that proposal, the court wanted to know.
I'm just addressing the bar, Mr. Sigdar and others. We may not have time to take any other matter because we'll be rising for single bench at 3:30. So there are prayers for upgradation. The court master will look into three matters were requested to be upgraded. Court master will take a call. We'll list it tomorrow or day after tomorrow.
But then, my lord, perhaps your lordship may like to admit this, and my lord, the only thing, my lord, why I'm trying to satisfy your lordship is whether that one post should be kept vacant or not, my lord. That is my learned friend was objecting to that.
No, means by the time we hear and we pass orders, since we'll be rising at 3:30 for the single bench, I might as well excuse the other lawyers.
That is what, my lord, we lawyers always expect from the court, my lord, so that we get free
No, that is the only good thing I remember.
of Justice Jain Sharma, my
I need not say the name. You
lord.
understand with this.
Others may go.
Others may go.
Your lordship may kindly peruse the order dated 26/9/2024 first. Then, my lord, the instructions came, and that has been recorded in the order dated 22/10/2024.
Okay, we,
We have given the copies.
Huh?
We have given the copies.
huh,
In terms of the last order dated 26/9/2024, Mr. C.K.S. Barwan has produced the instruction to the effect that no notification as regards selecting translators could be traced out in the Directorate of Information Public Relations District. So, my lord, there was no instruction, my lord, no document to show that the government took any decision. In the affidavit also, my lord, there is my statement to that effect, my lord, by their affidavit.
Page 150. Page 150.
And the other aspect is, my lord, because factually, my lord, this finding of the honorable single judge is wrong. And other aspect is, my lord, the honorable single judge has held that there has been past practice of promoting the translators to the information officer, junior information officer. And on that basis, my lord, the prayer of the petitioner was rejected. That is an error on law, my lord. Because there has been,
past practice, divorce of rules.
yes, my lord, these are the rules. So we cannot
We
do.
have doubt unless,
So precisely that is my case, my lord.
because one mistake done cannot be perpetuated. Even if one such incident happened, you have to treat it as subject to what Mr. Nath says. It is subject to be treated as
We
an
placed,
erroneous decision.
we
which
placed
not
two
be precedent.
decisions, my lord, in the written argument that was also there, that has not been discussed by the honorable single judge. Unfortunately, my lord, one is 1997 6 SCC 766, and the other is
Just a
98
moment. Please be slow. 19.
My lord, 1997 volume 6 SCC, page 766.
Name of the parties.
ICAR, Indian Council of Agricultural Research versus TK.
ICAR.
ICAR versus TK Surya Narayan. And the other is, it will be put to some.
No. You have given us is D. Stephen Joseph versus
Yes,
Union
my
of India.
lord. Yes, I'm relying on that also.
Okay. No, there's only one citation. Huh?
These Stephen Joseph versus Union
No,
of
this
India.
has come. Yeah, this PK. What is the name?
TK Surya Narayan.
Surya Narayan.
Relevant paragraph will be paragraph 8.
Paragraph 8.
My lord.
Of Surya Narayan.
My lord. And the other, another, my lord, judgment, 1998, volume 8 SCC.
The Surya Narayan is different. The Stephen Joseph is different.
Different.
Oh, okay. Yes. In this Surya, in this D. Stephen Joseph, what is the paragraph?
Paragraph, my lord, paragraph 5.
Paragraph 5.
My lord.
And third decision is?
In my lord, TK Surya Narayan, my lord, paragraph 8.
Yes, that you have recorded. K. Kuppuswamy.
My lord. K. Kuppuswamy, my lord, that is key judgment here, sir. 1998 8 SCC, page 469, K. Kuppuswamy versus State of Tamil Nadu, paragraph 3.
Lordship, 3 of them are.
This is paragraph
my lord, put to sum is paragraph 3.
3.
It's a very small judgment, my lord. 1 page judgment. Statutory rules
Merely
cannot,
because government has taken a decision to amend does not mean rules to be obligated.
yes, my lord.
That only one line.
Yes. And here, my lord, there is no decision of the government.
Okay.
So the honorable single judge has heard, my lord, both in law as well as on facts. And therefore, your lordship, my lord, that there was a stay order all through, my lord, keeping 2 posts vacant, my lord, that order also I can place, my lord, it was there. And therefore, now, my lord, 1 appellant, so 1 post may be kept vacant, my lord, till the matter is finally decided. In the meantime, my lord, there has been a move to amend the rules, my lord. There, we do not have anything to say. That rules may be retrospective, may not be retrospective. But the, my lord, our concern was that, my lord, the respondent number 7, who has been promoted, she is also a part of the, my lord, that committee. So bias on the part of the, my lord, authority, more particularly the director, is, my lord, apparent.
Which is that you gave us on that day communication that respondent number 7 is a part of.
Yes, my lord, that we have provided a copy.
Yes.
Extra copy is here.
No, it's available.
There your lordship will find the name of the one of the members, the last name, my lord, Srimati Mochumi Bhattacharya. She is the, my lord, respondent number 7.
Oh.
Who has been promoted contrary to the rules.
Okay. Okay, what is the date of the promotion order?
Promotion order.
And which page is that?
Page 75. Dated 12/4/2024.
12?
22, sorry.
12/4/22.
Page 75.
In this notification, serial number?
My lord, it will be at page, my lord, 76, the 3rd paragraph.
Okay.
Subject to reversion without notice and without assigning any reason thereof, Mochumi Bhattacharya, translator, is promoted to the rank of junior information public relation officer.
Yes. Yes, Mr. Nath.
Lordship, may kindly take up the judgment of the at page 302, paragraph 24. But I sample submission before the lordship is. In paragraph 24, the line single judge has noted the issue that arises for consideration is whether promotion from the post of translator can be made to the post of junior information officer under the 1986 rules, when the rules does not provide translator as a filler post for promotion to the same post of. This is the issue before the single judge, and while deciding this, the main one of the point which the single judge has considered, that whether the post which are mentioned in the rule as feeder cater for promotion to the post of junior information officer and a translator which is not mentioned in the rule is equivalent or not. That is the main thing he has considered, and which is permissible as per rule 3(2). That was the consideration. Kindly come to paragraph 25. But it is apparent that in terms of rules 11(2)(5), an officer holding the post of journalist, sub editor, proofreader, and librarian are only eligible for promotion to the post of junior information officer. However, it appears that under Rule 3(2), the service may also include any post equivalent to a post in any of the cadres mentioned in sub-rule 1, and any cadre of post laid down by government to be included in the cadre of the service. Apparent in addition to the cadre prescribed under 86 rules, the state government may either include any post equivalent to a post in any of the cadres mentioned in sub-rule 1, and any cadre of all posts laid down by the government to be included in a cadre of the service. So this was the basic thrust of the consideration of the single judge, whether the post of translator is a equivalent post of that post of the feeder cadre post which is mentioned under 11 to 5 on. Then done under the 1986 rules, the government has a power either to take any post equivalent to a post in any of the cadres mentioned in sub-rule 1 of Rule 3, or take any cadre or post to be included in a cadre of the service, though such cadre or post is not included in Rule 3(1) of the 1986 rules. But I'll refer to the rule once more and the affidavit filed by the respondent in the matter law. Look, Rule 3(2), Lordship will find at page number. It is at 137. Rule 3 starts with.
It is same thing we are referring from here.
Same thing. Internal.
Rule 3(2).
Rule 3(1) can become first.
3(1).
3.
Yeah,
Class,
yes,
cadre, and status.
3(1).
3(1).
Yes.
It defines the class, cadre, and status. 1. The service shall consist of the following class and cadres: A, class 1, class A, then B class 1, C class 2, then C, D class 3. Then next page kindly come to 2. So these 3(2) provides that the service may also include A, any post equivalent to a post in any of the cadres mentioned in Rule 1. Rule 1 contains all the classes and cadres. And B, any cadre or post laid down by government to be included in a cadre of any of the service. So whether the post is equivalent or not, that is the main aspect. Then Lordship may kindly come to the affidavit filed by the respondent in the repetition. Relevant will be Lordship may kindly come to page number. It starts at page 112, paragraph number 5. This is the stand taken in the repetition. Kindly come to 113. The paragraph continues to the next page. At the middle, fairly similar. I'll read the paragraph of the entire paragraph. Para 5, 112. The deponent begs to state that the gradation list of translator, journalist, missing journalist, sub-editor, and proofreader, librarian, proofreader of the Directorate of Information and Public Relations, Assam, issued by Office Order number so-and-so dated 25/11/20 and number so-and-so dated 13/12/2022 has been prepared on the basis of seniority and merit. Preparation of the gradation list like this has been a practice for decades. These posts are of same pay structure and nature of work. It is same for all these posts. It may also be mentioned here that the petitioners, namely Sri so-and-so, librarian, are recruited with the incumbents presently holding the post of translator, journalist, sub-editor, proofreader, missing journalist, for the same selection process completed in 2019. All these posts are advertised by advertisement number so-and-so dated 30/10/2018. All these posts are same pay of same pay scale as per ROP 1964, ROP 1975, ROP 1979, ROP 1981, ROP 1998, ROP 2017. The report of the Assam Pay Commission 1979 also mentions at para 7 of page number 204 of Information and Public Relations Department that the Commission recommended a higher revised scale of rupees 620-1315 for the post of journalist, translator, librarian, sub-editor cum proofreader in consideration of their duties and responsibilities and entry qualification. Similarly, in the year 2012, by the advertisement number so and so dated 27/7/2012, and also in the year 2016, by the advertisement dated so and so 22/1/2016, translators, journalists, sub-editor cum proofreaders, librarians were recruited together, considering the same nature of their duties and responsibilities. Promotions are done on the recommendation of the Departmental Promotion Committee on the basis of Rule 5(2)(a) of the Assam Public Service Commission, Assam Public Information and Public Relations Service Rules 1986. So look, this is the basic stand taken in the affidavit, and the Honorable the learned single judge, while deciding the matter, has also noted the issue at para 25, 24, and 25 to the effect that whether, although the post of translator is not in the feeder cadre, can be considered or not as per Rule 3(2). And that has been Malab. I have read Malab para 24, 25. Kindly come to Malab. In fact, para 26 also. As such, kindly come to para page 303 Malab again. That I have just referred to the stamp taken in the affidavit, and that has been ultimately considered by the civil judge, and while deciding the issue, that has been considered. This is an affidavit possibly filed by the private respondent.
No, director.
Mostly it starts at page 119. This affidavit, page 135. This affidavit is filed by our affidavit. This is our affidavit. Yes, ma'am. He has referred to this advertisement and all. There, the qualification and everything has been stated. This is the record, if necessary, I have to place it up. The advertisement, in the same selection process they were appointed. It is not disputed. If necessary, I have to place it.
How does this alter the position if there is a recruitment advertisement, which is a common advertisement for appointment of journalist, translator, librarian, sub-editor? Is it your case that somebody applied for journalist, he was appointed as a sub-editor? So it's a specific post-wise advertisement. So it may be a common advertisement for various posts. It's not like APSC that you get selected in the examination, then you are selected for ACS or for IPS or for so it's not like that. So once it is specific, whether the pay scale or the grade pay are same or different, how does it matter?
Because we want to show the equivalency. We want to say in the affidavit they have stated that the post they are holding, which are feeder cadre in that.
No, we'll tell you why. I have a very simple answer. Correct. My sister will watch for that. You see, a judicial officer of grade 1 if it gets a super time scale, maybe he or she would be drawing salary higher than a High Court judge. Are you aware of that? You're not. It may happen. Now, can you say that because equal salary is drawn, he's an equivalent post?
Here, one of we have two contexts. Number one, that the as per ROP, all the pay scale and that is number one. Number two is duties and responsibilities are same. Both the things we have stated in the affidavit.
No, that would be a proofreader. A proofreader is a proofreader. A librarian is a librarian.
Look, in fact, although the nomenclature is different, that is the same the nature of kindly towards the end of the affidavit, the same nature of their duties and responsibilities.
No, but how?
Look, in fact, the learned single judge has, while deciding the matter, has again considered that. I'm about to take your lordship to that. Just for a moment, if kindly comes to lordship 310, page number 310. This was noted in paragraph number 34.
Because when it comes to the name of journalist,
duties and responsibilities can be seen, column. My lordship may kindly come to 310. This is a part of para number 34. This continues to page 310, internal page 22 of the judgment. There, my lord, information and public relations. This is the department, and there lordship poster mentioned the journalist, translator, sub-editor, proofreader. The fourth column, can you see nature of job of this feeder cadre is almost similar with that of the next in the hierarchy. As regards the Department of Information.
you're reading page 307.
I'm reading 308, paragraph 34, it starts.
Yes.
There kindly come to, it continues to 310.
Yes.
Kindly come to 310. I'm straight away taking your lordship.
Okay.
I'm on duties and responsibilities of this post. Kindly see the department is fishery is number one. Second is information and public relations. They in that department posts are journalist, translator, sub-editor, proofreader. Then in the fourth column in the right hand side, what you will find the nature of job of this feeder cadre is almost similar with that of the next in the hierarchy. As regards the Department of Information and Public Relations, the nature of job of this feeder cadre is almost the same with the next higher post of subdivision information and public relations officer performing field duties such as coverage of meeting, events, various public relations activities like publication of booklet, leaflet, etc., translation of budget speech of the Honorable Finance Minister, speeches of the Honorable Governor and Chief Minister during Republic Day and Independence Day, etc., along with election duties during parliamentary and assembly elections at the state election department and various such activities. So, while deciding the issue at paragraph 24, my respectful submission before your lordship is that the learned single judge has considered that the duties and responsibilities are similar.
No, you see, is it your case that this, the author of this letter,
Director.
para 34 letter, which is the in charge director of information and public relations, please tell us what is the post he was holding or substantive post? Are you aware? No. He's an in charge. Okay. Now see, is it your case that this in charge director, everything he says is a gospel truth? You see, there is a reason for it. This question. You come to page 309, nature of job and function, he says. Now, is it a documented nature of job and function, or this is he's the editor of this note? Is it a government policy which is being reflected here, or it is just his assessment?
In fact, this is a letter of 9th of March 2018.
We understand that, but this column 4 and the entries made herein, is it a part of any government record, or this is his explanation, his reading of the nature of job, comparative job?
That I have to, but I have to.
You get it? We now will tell you why. This content of the letter, where if this is something which is born out of the records, then it's an acceptable proposition. But if it is a note of this officer, then it's merely a note. It doesn't become a government letter. It's not a government opinion, because the government opinion will come from the secretary. This director is no authority to take the what you call, to say on behalf of the government.
Do agree. That is the correct position, but I.
Because here he is giving a comparative statement. We are questioning this because of the fact that you look in the part you read, page 310.
Yes.
The nature of this feeder category is almost similar with that of the next in the hierarchy. As regards Department of Information, the nature of this feeder category is almost the same. Next higher post of subdivisional information officer of so-and-so and coverage of so-and-so. And about speech of so-and-so. And in the letter, he is referring to the other departments. The pre-page is referred to counterparts of Director of Agriculture and Animal Husbandry, which fishery, details of the comparison as per ROP 2010. So comparison is something which the government will never do.
As per ROP 2010,
So he's comparing all these departments, and then he's giving and he's referring to the finance department also. So because it's a comparative study of all these departments, that is what he's saying is the same nature of job.
for the.
Equivalent will be declared only by the government as per your own rule. So unless you say that the government in its wisdom has delegated this authority to the director.
That is an aspect of it that I have to clarify. Well, it is of course one of the government has to clarify that. That is obvious.
Under Rule 3.2, then this is the director is not a government. If director is not a government, then the finding would be incorrect. For the purpose of just for the purpose of stay, we are just deliberating. We are not deciding the issue right now.
Ultimately, logic definitely has to decide the issue. The issue cannot be decided at this threshold today. I'm indicating now that while deciding the petition, the prime consideration of the learned single judge is whether the translator post is equivalent or not. Equivalent in respect of two things: pay and other benefits, and duties and responsibilities. That particular two things he has considered. And as per following rule 3.2 of the rules, that since it is equivalent, therefore at paragraph 24 that issue that he has not quoted, that even if it is not a feeder post, whether promotion can be given by the court, given by the authority under 3.2 or not, that has been decided in favor.
We are not saying that the process is erroneous. The learned court has the learned single judge has formulated the issue and decided it. There's no difficulty in that.
Considering the nature of the duties and responsibilities of the post held by the translator in the directorate, and that has been in the consistent stand in the affidavit as well as the clarifications on our court. That is the
So nice of him. So nice of him. Man. Yes.
Since I am insisting on that one. But next is the para 38. The learned single judge has considered that that the past practice, long-standing practice is also a relevant consideration. So ultimately on these two issues, he has passed it.
Where in this affidavit you have referred to the past practice? Where are the documents for the past practice?
Past practice. Paragraph, paragraph, 7 में can you see? Para 7 में.
Page number?
Page number 115.
115.
Can you see 114, para 6?
Yes, 113.
The persons holding the post of translators were getting promotions. Has also got para 6 subpara. There is a subpara. 114.
Yes, page 114.
1.
Para 6 subpara.
Yes. The persons holding the post of translator were getting promotions to the post of junior information officer since decades, as and when there were vacancies. Accordingly, with such a long history of promotion from the post of translator in this directorate, the respondent number 7 was also given promotion to the post of junior information officer and posted as press research officer.
Yes. But what is the instance given? But in the same paragraph, you have already stated that no such notification order could be traced out in our directorate. And the reference which is being made is for Home Department.
Yes. Because it was that point of time possibly not bifurcated. Maybe. I have more to take it. It was by bifurcating the Home Department, because the Information and Public Relations Department was created as a separate department by bifurcating Home Department subsequently, like in 97. Earlier it was on the Home.
But then you see, when it was a Home Department, they had a rule. Comparative rule, we also don't know. And after this, when the department is bifurcated, you have your own service rules for this.
Yes.
So last time before rising, we posed this question that rule definitely is normally under 309. So can an administrative fiat override Article 309, power of the governor?
No, here the rule itself is there. 3.2.
But 3.2, you see, this is only an opinion of your directorate. It's not even the opinion of your government.
That I have to. Because the rule 3.2 coupled with the natural duties, because the equivalency is the criteria there. I will get the instruction of whether what the government said.
But then this stay will continue for one post.
Well, my prayer would be, I have taken the instruction that whether they have in the meantime filled up or not, that because that was my apprehension on the other day. But nothing.
Okay.
So only I will pray for the short date.
Short date now goes to after the holidays,
I have to take the instruction. After the bill, not a fixed day.
after BU.
Not. I have to take the instruction in the meeting.
Okay. Suggest a date, 22nd of January.
Not.
22nd of January. There's a calendar before you? No. You've not placed a calendar before you. You have a calendar of May there. See May, it will be same.
22nd is the Wednesday.
22nd is Wednesday. May and January will be same. Put up a photocopy there also, huh? Tomorrow. Give it there. So 22nd, but the stay will have to be extended till then.
One post. One post.
One post.
Yeah, one.
Huh.
The lordship says no status quo because on the other day professor.
No, status quo may have a ripple effect to somebody else. We don't know. I am very jittery of passing orders of status quo where we don't specify what exactly I'm doing.
Because on the other day, professor till 3:30.
Not so it's okay. Means I have told you the reason why I find it very difficult to pass a blanket status quo order, because where it goes we don't know. Who will be affected by the order we don't know, and what is the specific direction, or what we actually want out of this order. It's not specified. May lead to some heartburn somewhere.
22nd, and in the meantime, I'm appealing for 1 to 5 months, for others who have notice as well.
Ah, yes.
এখন ক্লিয়ারিফিকেশন চাইলে এখনো উপর আর কখনো উপরে এখন ক্লিয়ারিফিকেশন চাইলে তো ক্লিয়ারিফাই করলে তার পিছনে পারহাপশন এগুলো সেক্রেটারি এটাকে বেশি হয়ে যায় মানে একটা ডাইরেক্টরেট হয়ে আছে ক্লিয়ারিফাই করলে হোম ডিপার্টমেন্ট ডাইরেক্টরে এখানে ক্লিয়ারিফাই করলে এই লেটা এখন উপর এইটাই গেট করলে কিন্তু একে গতিকে আর নোট ছাপা আছে মোটর আসলে গো হেড দিলে এটা
Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. A. Fukan, Learned Counsel for the appellant. Also heard Mr. D. Nath, Learned Senior Government Advocate. Appearing for respondent numbers 1 to 5, and Mr. P.P. Datta, Learned Standing Counsel for respondent number 6. Next para. By filing this intra-court appeal, the petitioner, who was the respondent number?
No, I was the read petition.
Who's the petitioner number?
Two.
Petitioner number 2. In
WPC number 4538 of 2020.
WPC number 4538 of 2023 has assailed the judgment and order dated 21/11/2024 in the said writ petition, by which the writ petition was dismissed. Next paragraph. In brief, the case projected by the appellant is that in the said writ petition, the promotion to the respondent number 7 was assailed on the ground that prior to her promotion, she was holding the post of translator in the establishment of the Directorate of Information and Public Relations. And what is PS?
Printing and stationery department.
And Printing and Stationery Department. From a Government of Assam. Within bracket DIPR for short. Full stop. It was projected in their petition that that on a combined reading of Rule 3 comma 11 within bracket 2 and Rule 9 within bracket capital no small Roman 5 9(5) of the
Rule 11(2)(5).
huh?
Rule 11(2)(5). 11 subclause.
Okay,
Roman
11(2)(5).
Subclause.
Okay, 11(2)(5).
Roman test.
11(2)(5) and Rule 9 within bracket small so not 9.
3.
Three you cited 3 provisions. One was 11(2), 11(2)(5). Rule 3 and then I made a mistake in my note. You take only 2 rules. Comma. The post of translator was not an encarded post under class 3 service. 3 Roman 3 service. And therefore, the avenue of promotion was not available for the persons holding the post of translator. Full stop. Accordingly, comma, it is projected that the learned single judge, while deciding the writ petition, arrived at an incorrect conclusion that in terms of rules P within bracket 2 within bracket small v comma based on communications dated 16/8/1994 and 21/9/94 comma referred to in paragraph 28 and 30 of the impugned judgment, comma the post of translator was equivalent to the post of
Library.
librarian next paragraph. Opposing the issues of notice in this intra-court appeal, the learned senior government advocate has referred to the issue which was formulated by the learned single judge in paragraph 24 of the impugned judgment, and it is submitted that the learned single judge had recorded his satisfaction that the post of translator was equivalent to that of journalist, sub-editor, proofreader, and librarian. And the court was also, and the learned single judge were also satisfied that there was a long-standing practice in the DIPR for clubbing the journalists, translators, sub-editor, proofreader, proofreader to be clubbed together. And accordingly, it is submitted that the person holding the post of translator was also entitled to be promoted to class 3 posts. Next paragraph. The issue raised in this appeal requires further examination. So accordingly, the court is inclined to issue notice returnable on 22/5/2024, 22/1/2025. Next, extra copies of the memo appeal be served on the learned in the office of the learned senior government advocate, as well as to the learned standing counsel for respondent number 6. You will be appearing for 1 to 5.
1 to 5.
Extra voice on behalf of respondent was 1 to 5. Mr. Sorry. No. In the first para, Mr. Nath appears for respondent was 1 to 5. Next para. Issue notice returnable on 22/1/2025 upon respondent numbers 7 to 11 by registered post with AD. You will sub by Dasti also. So in addition, the petitioner will make an attempt to serve notice on the respondent number 7 to 11 by way of Dasti. Post of the process shall be routed through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next para. In view of the stand taken in where is it that affidavit?
110.
Para 7,
Para 7.
115. You have the statement made in the affidavit in opposition filed by respondent number 3 to the effect that to project that there was no notification, that no notification or order could be traced out, facilitating promotion of translator to junior information officer in the DIPR on the court is inclined to provide that the interim order passed on 13/12/2024 is stand modified to the effect that one promotional post of
Junior information officer.
junior information officer within bracket class Roman 3 post shall be kept vacant till the next date of listing. Next paragraph, list on 22/1/2025.
For admission.
Can we show you on this?
So this orders keep in the take it and keep it in the record.
But I have one submission. Lordship has said that there is a practice of clubbing the post. Well, in fact, we said that there is a practice of promoting, a long-standing practice of promoting the translator to the post of
Instead
junior.
of clubbing, say promotion, because your word used here is clubbing.
Clubbing.
In your affidavit, you use the word clubbing. Look at that.
But it's a long-standing.
No, it's okay.
Logic.
Which is instead of clubbing, made it long-standing practice of promoting.
Practice of promoting translator to the junior information officer.
Say like that. Okay.
I'm obliged.